My name is Russ Mead. I'm the Shared Earth Foundation visiting professor at the Center for Animal Legal Studies at Lewis and Clark Law School. I know a lot of you, and a lot of you know me. I was general counsel at Farm Sanctuary and general counsel at Best Friends Animal Society. Did a short stint as executive director of Farm Sanctuary, and then I started teaching. So for the last, maybe 8 years or so, I've been teaching at Lewis and Clark. Now, long ago, we were talking about these conferences, and it came to the idea that we need to find a way that we can get these elusive ethics credits. So we came up with this format, and remarkably, it is stuck. So I've been asked to give this presentation every year at this conference, and I'm also giving a similar presentation to animal law sections across the country when they have their annual animal law conferences. So with that, we're going to jump into a hypothetical. And this hypothetical is not subtle. We're not talking about the nuances of professional responsibility. We have this fictitious lawyer, Billy Miller, who is out trying to help the animals. And she's a lawyer, or they're a lawyer, and does absolutely everything wrong. And the reason that I use this format is to remind us that we are practicing lawyers, and we are bound to the rules of professional responsibility when we're doing our advocacy work, our volunteer work, just as much as when we're doing our professional work. The rules are the same. And so I constantly hear of cases and know people who would never dream of violating a rule of professional responsibility, but absolutely have no problem in violating it when they're out helping the animals. And of course, that's violations for state law everywhere, and we just need to avoid it. So this is the format that we can talk about this, we can have fun with it, and then it reminds us, okay, we're gonna have to follow the rules. So let's start. It's time, once again, to talk about the crazy antics of Billy Miller. If you've been to one of these conferences before, you'll recognize Billy as the animal advocate lawyer who always seems to do things wrong when it comes to the rules of professional responsibility. This time, Billy is a land use lawyer. There's a lot of work for Billy in the rustic western town of Wild Horse. Wild Horse is in the high desert. It's in the past dominated by ranching, but now it's dominated by Western-themed art galleries and trendy restaurants. Tourism's the #1 industry in town. But really, Billy is a real character, if you've heard these before. This year, Billy is driving a 1972 F-150 pickup truck with a brushed aluminum vintage camper, and Billy painted on the side, "The dog is friendly, the animal rights lawyer is not." On the side of, Billy lives in an 1880 adobe house. Most of Billy's neighbors are now trendy tourist shops. Billy goes everywhere, and this actually describes my dog, goes everywhere with a 40-pound yellow street dog named Charlie. Charlie's female, spayed, friendly with people, but will absolutely dominate any dog of any size. Billy gets involved in whatever animal issues crop up in the community. The county that they live in owns huge tracts of land of high chaparral desert. For 150 years, the county has leased out this land to ranchers. The land has also been home to a band of wild horses. The issue: the land is being overgrazed by the cattle and the wild horses. A meeting was called by the wild horse advocacy nonprofit named 1521. That was the first year that there were sightings of horses in North America. Billy attends the meeting of this nonprofit. The discussion turns to the Federal Wild Horses and Burros Act. There's a question about whether the act covers these county lands. Belinda Chavez, 1521's executive director, sees Billy in the back row and says, "Hey, Billy, the Wild Horse and Burros Act applies to public lands. Are the county's lands public?" Billy answers, "Well, of course. Lands are either public or private. Those lands are not private lands." Actually, Billy had no clue about the federal act applying to these county lands or not, but Billy just didn't want the town folk to know that she wasn't knowledgeable. Well, just a heads up, Billy got that flat wrong. The animal community is split on how to help the horses. The 1521 Horse Advocacy Group is advocating for a roundup and sterilization of a portion of the herd. 1521 also wants to reduce the number of cattle grazing on the land. After the meeting, the executive director, Melinda Chavez, walks up to Billy. Melinda starts out, "Billy, why don't you go talk to somebody at the county and let's see if we can get those leases cut back?" Billy answers, "Yeah, I'm good friends with Sylvester Walters, the latest county commissioner. You know, I think he had a crush on me in second grade and he's never really gotten over it." Then Melinda fires back, "Well, use what you got, just let's help the horses." Billy's dog Charlie has an active Twitter account and comments on almost everything in town. Because Charlie has paws and not fingers, Billy does the posting on Charlie's account. So Charlie/Billy posted, "Those damn ranchers are starving our Mustangs. Mustangs first." But then someone named Cross-Eyed Harry, whoever that is, responded to Charlie's blog post. "Charlie, do you think the county could ever use some of that grazing land to build a dog park?" That was the question came in through the internet. Charlie, or well, Billy, responded, "The land you're talking about is zoned agricultural 1. The dog park idea is great, but the zoning would need to change to agricultural 2. This time Billy got it right. This is an accurate reading of the law. The next week, Billy has a chance meeting with another horse welfare group, the Free Running Society. Bonnie Smith, the founder, bumped into Billy at the Tractor Supply store. Billy was buying dog food. Bonnie got into a yelling match with the store manager over the store selling baby chicks in the store. But then Billy told Bonnie that Billy would represent Bonnie if there was any trouble with the incident. In the parking lot, they started talking horses. Bonnie suggested that the county stop leasing land to ranchers altogether. This would allow the horses to run free and not be sterilized. Billy commented, "Yeah, that's interesting. I'm planning on seeing the county commissioner, Sylvester Walters, soon. I might mention that." Billy gets busy on highly contested short plat issue that she's getting paid good money to do and does nothing on this issue for the next 4 weeks. All right, so your job, talk amongst yourselves and see what you think about possible things that Billy has done wrong in the rules of professional responsibility, and then we will be back. All right, let's come back. So what I'm going to do is ask for things from the floor that you think we might want to talk about in terms of the rule of professional responsibility. And then I'll paraphrase the question back out for the folks that are joining us online. And so I don't think we're going to need to come to the mics. So just to holler out, what's one thing that strikes somebody here? I'm sorry? Told them the wrong law. All right, good. I mean, absolutely did not have the answer. Now think about your own practices. I mean, you would never think about answering a legal question with, even if you think you know the answer, I mean, we go check it out, right? We go onto Lexis or Westlaw, or we do whatever to make sure we understand the answer. There's the rule of professional responsibility is the one dealing with diligence, rule 1.3. And, it says that you've got to get yourself up to speed on this. Now, that doesn't mean that when you take a case, you need to understand everything. But before you're giving out advice, you need to be competent in diligence. The diligence piece says that you need to jump on it and do the actual work. So the problem isn't as much as they got the wrong answer, didn't even bother to try to find the right answer. Again, we would never do that for a paying client. We should never do that in a volunteer setting. So great. What next? Right. Right. So there's that rule. I mean, and if you're giving out any information about a client, they have to agree to it. And there's another segment that's going to deal with that as well. I'll cover it now. Most people don't realize that the confidentiality rule with your client's information does not only cover rule or information that you received in confidence. It also covers all information that you know about the case that came from public sources. Highly misunderstood rule. So we just can't talk about anything to do with our client representations unless we have approval from our clients. That's shocking to lots of lawyers. I mean, you think about all the times you're asked, questions and you're talking about their cases and cocktail parties and everything else. There is a practical workaround. There's a best practice though. What I recommend is in your engagement contracts that you go ahead and specify what types of information the client agrees that you can talk about. So, possibly non-confidential information about their case. And clearly, we're allowed to use any information that we know about them to help them in representation, but I'm talking about these other things. So good. What else? What else do we see? Yeah, there's a lot. Yeah. Mm-hmm. Right. There's a possible conflict there. There's also another issue, and we don't think about this enough. Is that person now a client of Billy's? Somebody asked this question, Billy fired back an answer, and we find the answer to that in the preamble to the model rules. And this is something we should listen up to because, again, it's not something we don't normally talk about. So this is the preamble, paragraph 17. Furthermore, for the purposes of determining the lawyer's authority and responsibility, principles of substantive law external to the rules determine whether there is a attorney-client relationship. Now listen to this. Most of the duties flowing from the client-lawyer relationship attach only after the client has requested the lawyer to render legal services and the lawyer has agreed to do so. Now let's think about what happened. There was a post. There was a legal question asked. Billy gave a legal answer. Doesn't that exactly fit this? Does Billy now have a new client who she doesn't even know? I would say Billy does. We should not be answering questions that just flow in from the internet. And expect anything other than now we have a relationship with that person. And that should just scare you a lot if you're in there running blog posts, right? So be careful. It doesn't take much to establish an attorney-client relationship. Somebody asks you a question, you give them an answer, welcome the new client to your portfolio, which means everything that goes along with it. Confidentiality, trust accounting. You have to interview them to make sure you understand their facts. All of that from answering a question. Does that scare you when you think about bar association chit chat around, when you all get together? It should. We're violating the rules of professional responsibility when we do that. Anything else? Yeah, there is that. Let me put it this way. I don't see many disciplinary hearings on this type of thing at that kind of distance. Yes, technically I'd say yes, but I don't see that. I don't see that a whole lot. All right, let's move into the next section. Billy got into a road rage incident with Trent Sanders. Trent runs the Mustang Chasers. Now this group is going to anger you. It's a group of dirt bike riders that chase wild horses. After being cut off by Trent Sanders, this is as they're driving down the road, Billy yells, "Hey, I had to slam on my brakes. My dog Charlie was thrown into the front seat." Then continued, "If you don't stop messing with me, my dog Charlie is going to post about your cousin Molly's arrest for shoplifting those Twinkies last week at Circle K." Trent fired back with a string of foul language that I'm certainly not going to repeat on a recorded CLE. Then next up, so a whole new section, Billy finally gets around to going to see the county official. Before going into the county building, Charlie gets into trouble. This is a dog. Charlie gets into trouble for once again mounting at some tourist Labrador that was walking down the street. When they go into the office, Charlie, again the dog, jumps into the commissioner's lap. Charlie's looking for someone to scratch behind the ear. Then Billy tosses a veggie Subway sandwich over to Sylvester. So this is an elected official. The official says, "Thank you, Billy, but next time bring the cheesesteak." Billy responds, "Sorry, Sylvester, in this state it can't be a bride without steak inside." Then Billy gets into the heart of the matter. "I'm talking to two different groups, and they're both mad at you. The 1521 group wants you to cut back on some of those obscenely cheap grazing leases. And while you're at it, they want the county to spay and neuter a portion of the herd to reduce the herd population. But that's not the worst of it for you. The Free Running Society wants the county to totally get rid of those land leases. They want you to turn all of those lands back to the horses, just like it was before the ranchers got here." Sylvester, so this is the county official, starts eating the sandwich and then pulls out a jalapeno, asks Billy if Charlie can have it, and Billy says, "Well, sure, but just one. Charlie loves him a bit too much," so he goes ahead and eats the spicy food. Sylvester then says, "Hey, look, Billy, there's just no way we're going to stop those land leases. The ranchers have controlled the politics in this place since before your grandparents even moved here. But the tourists really like the horses. I can see the business owners supporting at least a reduction in those leases to help tourism." After the meeting, Billy gave a readout of the conversation to the commissioner via blog post. She's going to tell the world what happened here. Billy, or should I say Charlie, posted, "I went to see a county commissioner. There's no way the county is ever going to consider getting rid of all of those land leases. But there might be some room to cut back and make some more room for the horses, cut back on some of the land leases. The tourists just love the horses." As you can imagine, the internet explodes. Everybody is now mad at Billy or Charlie. The 1521 group doesn't like that Billy announced all of this publicly instead of coming and having a private meeting. The Free Running Society absolutely was angry that Billy pitched both of these ideas to the commissioner at the same time. Charlie was frustrated. Well, Billy, Charlie, frustrated, responded back, "Look, we're just trying to help. We're not going to work on this anymore. Wild horse people, you're on your own." So talk amongst yourselves and see what rules of professional responsibility might come into play. Maybe how Charlie, Billy could have done this a bit differently. All right. Let's come on back. So what jumps out at you? Massive conflict of interest. Yes, I mean, of course. So it's rule 1.9. I mean, you can't take on a second client or a third or a fourth that's substantially in the same matter where the interests aren't aligned. So what we often see in animal rights, animal welfare advocacy cases is, we'll represent multiple nonprofits, for example. I mean, a lot of the cases we heard in the last, session, multiple nonprofits, but their interests are aligned. But they also need to agree that you're going to represent multiple parties. And one of the things that happens, it's what I call the case of the shifting client. I mean, these are my terms, but I think it's pretty descriptive. So we've got some issue in the community. We figure out as animal advocate lawyers who seems to be getting the most traction, and then we jump in, we try to help them. It's like, okay, that group, I mean, they're really on it. And so I'm going to let them have my legal opinion. I'm going to put my legal education to work for them. So not the large organizations that have their own in-house counsel, but all these small ones that don't. And so you're in there working with them. And then for some reason, they kind of fall aside. Either they're busy on other things, they don't care about it anymore, or they care about it less, or they've had some kind of conflict with some other group. Have we ever seen animal rights and animal welfare organizations not agree with each other? Of course, that's, we see that all of the time. And then the animal advocate will decide, oh, well, there's this other group. They're getting some traction on this. I'm going to go lend my expertise to them and going to shift on over and start helping them answer legal questions, to do whatever. So I call that the case of the shifting client. The problem is that, you just can't do that. If you're going to represent different people on the same, or different organizations on the same matter, their interests can't be adverse, and they almost always are. I mean, the nonprofits never see the same solution to the problem. I mean, we saw this last session, all these different ideas. And so you almost always have a conflict. I mean, it's the rare case when we don't. And even if the folks the nonprofits want you to help them both, you got to get approval from them that says it's okay. So that's one of the main lessons of this, is when you're doing your volunteer advocacy work, watch out for the case where you've gone over that line and you're now representing somebody, which again could be as simple as they would ask you a question, you gave them an answer, they're now your client. If you want to go help somebody else, I mean, you're in this conflict situation, which means you need to get waivers, or really that's about the only thing you can do, because your duties to them, carry on even after you withdraw. So yeah, conflicts are an issue, and it's a bigger issue than in other fields because we never agree on anything. So we need to watch when we're volunteering to make sure that we have a single client. All right, what else? There's a workaround to that though, because this is one thing that I talk to advocates about, and yes, go ahead. Right. And this is as actual as they can get. They both want to do different things. You can't not sterilize the horses and sterilize the horses and then both comply. I mean, that's why I built that in there. So you just have to be careful about when you take on these representations. Now, there's one thing that I'd like you to think about as just a practice. If you're not giving advice to these groups, if you're not their lawyer, if you're, for example, the general counsel of a nonprofit that you've created, now you're representing that group, the group that you started. And as long as you're not giving out advice to the other groups, you can go and do all kinds of work, but it's not under the umbrella of providing legal services to somebody else. So clearly, if I'm representing a nonprofit, I can tell other nonprofits, as long as my client agrees that I can talk about it, what we're doing, our ideas, our everything. And so that's kind of almost a safe harbor to think about if you're going to do lots of advocacy work. The conflict laws are going to exist. And I would say I don't know the organizations, but I would say that's a dangerous place to walk if they're both animal advocacy organizations, because You want the short answer? No. And here's why. Because when you're sitting at that board meeting, and I've certainly been in plenty of those board meetings, we can't keep our mouths shut. I mean, there is no way that somebody is going to say something, get the law wrong, and you not want to correct them. And let's face it, the reason people want us on the boards is so we can be their free general counsel, you know, if you're talking the smaller ones. So the short answer is, I mean, I could come up with some kind of trippy law school example on how that might work, but the short answer is no. You know, you're probably going to be giving advice. You're probably going to be representing the organization that you're on the board of. We just can't help ourselves. Remember, the criteria is small. They ask you to provide legal services and you give them. You're sitting in a board meeting, the CEO, executive director asks you a legal question, you give a legal answer, you're representing them. So be careful, I will say that. Hence the reason for these, CLE discussions, because you would never think about doing that for two different for-profit entities that were both paying you to do work, but it comes up in these volunteer situations. Great question. What next? Yes, all right, so for those outside, the comment was you can't terminate a client relationship through your dog's Twitter account. And while the rule doesn't exactly say that, that's clearly the rules of professional responsibility. Go read them. I mean, there's a whole laundry list of things you do when you withdraw from an engagement. But the one that sticks out to me the most in these situations is you have to give enough guidance on your way out so that the client can get other representation. Of course, you have to return, property and documents and things like that. Although that's not as much of a problem as, you should really be giving them advice on how they hire somebody new and helping them, shifting them over to the next lawyer. And just saying, I've had it, I quit, which by the way, I've seen plenty of people get fed up with a nonprofit they're volunteering for and just says, I'm done with these people, and walk away. And you have to look at that as a withdrawal. And then you have to get in there and figure out how to withdraw. And if you're in that situation, I'd recommend you pull the rule out to see what all the requirements are. But the main thing is to make sure they're taken care of. You just can't quit in the middle of the night and leave. What else do we see? There's more stuff in here. Yeah, so is the Subway sandwich that doesn't have meat in it, or is that a bribe? Yeah, so it's probably not a bribe, but what it does bring up is a discussion of what you can do and what you can't do. So one thing so if you're looking for a safe harbor, this is what I say. Small items that promote your community, your organization. If you're working with a nonprofit and they have a cool baseball cap, that's got a really witty animal saying, things like that are always fair game. In fact, when you go into elected officials' offices, they always have a place, where there's 50 coffee mugs from people coming and visiting them and give them. That's the proper level of gift. Now, when you start getting into expensive meals, I mean, now you're into the land of lobbying, and they may not be allowed to accept them, and you might have to report them, and you might have turned yourself into a lobbyist. And so know the boundaries. And so I throw out this example. It's not really on the edge, but it brings up the discussion. So the things that are fair game are small, cute things that represent organizations. You can always do that. If this was a $200 dinner, now we're into another land. So be careful on the food or on all of the gifts. What else? How about the Twinkie thing? If you don't remember what it was, if you don't leave us all alone, we're going to report out. Yes. Right, there's that. There could be just outright legal jeopardy themselves, but there's also I don't want to call it obscure because none of these are supposed to be obscure. We're supposed to follow them all. There's actually a rule 4.4 that says you can't take any action that's meant to embarrass a third party. So this is set up where it's a family member and it's to embarrass the third party to get something from the person they're meeting with. And there's just flat a rule against it. And the reason I bring it up is because in these, I mean, just caustic times, that we see in our political arena, people are saying all kinds of nasty things about other organizations or their family members. I mean, just look at the political thing, anybody's family member seems to be fair game. If you're a lawyer, you can't be saying things about somebody else's affiliated members just to embarrass them. If they're a third party, you can't embarrass them. That is a violation of the rule of professional responsibility. It may seem surprising with what we see on television these days, but it's a flat rule and it's been there a while. Let's see, what else? Oh, how about the actual meeting? Talking about both situations. We talked about conflict. Is there more nuance to that? There's clearly a conflict, right? You can't talk about one and two different ideas representing two different clients at the same time. So we've covered that up. All right, how about the blog posting? We talked about quitting, so you can't do that. But how does this make you think about blog posting in general? If you've got a blog and you're posting out legal information, I really caution anyone that is responding. If it's a two-way street and you're not posting one-way blogs, you probably have an issue. You probably have a big issue. Because think of what we're supposed to do when we have a new client. We're supposed to interview them. We're supposed to find out all the nuances of their legal problem before we respond. And we just don't do that if we're responding these off-the-cuff, reactions to blog posts. And so I would say stay away from them. I mean, if you got a one-way thing, if you're, whatever your area of law is, if it's animal law or if it's wills and trusts or whatever it is, and you're every week, posting something interesting about, whatever you're working on, make it a one-way thing so that you don't have that interaction. So if you're doing that, I hope it scares you a bit. All right, let's move on to the third section. So this is the fun one. This is the one where she gets into trouble for all kinds of interesting reasons. All right, it's time for the annual Wild Horse Art Show. The streets downtown are closed off. All the best regional artists put booths up. There's lots of food and there's lots of beer. The local Humane Society had a booth, but remarkably, the group forgot to bring any water bowls for the dogs that were attending the fair. The event coordinator, who knows Billy, asked Billy to go to the Tractor Supply, our good friend over at Tractor Supply, and pick up a couple of dog bowls so they could put the water out. The coordinator handed Billy a $100 bill out of the donation Folger's coffee can to cover the cost. Billy put the money into Billy's wallet. Then Billy and Charlie, the dog, went and picked up a couple of bowls. But first, Billy couldn't help themselves. They yelled at the store manager for selling the baby chicks. Then that night, the festivities continued. There was live music. This time it was Pure Prairie League. By the way, every time I give one of these, I have to look to see if the groups are still in existence, and Pure Prairie League is still out there. Billy unbolted the bench seat from her Ford F-150 and set it up right in the middle of the street so Billy and Charlie could hear the music. I've actually seen that done. A small group of animal lovers joined around Billy's bench. The locals who used dirt bikes to chase the wild horses was an avid topic of conversation. Everybody wanted to talk about them. Someone said, we should just put sugar in their gas tanks. That'll show them. They don't deserve to be riding out there with those beautiful animals. Billy had a simple response. Well, that's interesting. Billy made space on the bench for a board member of the 1521 group. So that's one of the horse advocacy groups. So it's a board member named Randy Renner. Now, I'm not sure if I'd call it dating, but when Billy came home from college one summer, Billy and Randy hooked up out in the desert after a kegger party. and they've been friends ever since. The sour ale, unbridled passion, was flowing freely through the night. It's another thing I do on these. I always look up some kind of a beer that seems to be in the same theme, and I always find one. There's always something out there. So unbridled passion is a real thing. And at the end of the night, Randy and Billy were too drunk to drive home. Imagine that. And unlike Portland, Uber had never made it to the town of Wild Horse. So at the end of the night, Billy put Charlie, the dog, into the front cab to bed down for the night. Then Billy and Randy climbed into the vintage camper. Then they took a trip down romantic memory lane. All right, talk amongst yourselves and see if you see any potential rules of violation of professional responsibility. All right, so let's come back. There's a couple of things that I suspect will jump out. Yes. Commingling of client funds, yes. So I had struggled with trying to find a way to talk about commingling. And there's always a question of, Well, would the Bar Association really come after you for, the change? What it does is it allows us to talk about this issue. So you can't commingle client funds with your funds. So the reason I bring this up is sometimes it's not $100, sometimes it's not $20, sometimes it's something else that you're going to come across in your life. And so I will give you what I think is a best practice. The best practice is if somebody asks you to do something like this, and they trust us because we're lawyers, they know we're not going to steal the money. We know we're going to make good choices whenever we're out there doing things for them. Go ahead and do whatever it is the client asks, but just don't take the money. Pay for it yourself, put it on a credit card, and then have them reimburse you. So now it's just a reimbursed expense like all of the other reimbursed expenses that you have running through your law firm or through your practice or from wherever. So you've totally avoided the problem of commingling because you've never commingled. So I think that's a good best practice to adopt. Never take your client's money and mix it in with yours on these small things. Just handle these situations that way. Yes. So that's a good point. All right, so she could do that. Here's the question. Does the Humane Society consider Billy to be their lawyer? Why did they pick Billy? So if the relationship came about purely from non-legal contact, you would be right. But this is the kind of stuff that gets us into trouble. Now we're sitting there debating whether we've ever done any work for the Humane Society. We're sitting there trying to figure out, do we have an attorney-client relationship? We could avoid it all with this best practice thing. So yes, I applaud the figuring out that might not be an attorney-client relationship, so the rule wouldn't apply. And I'm just going to say, my life is more complicated than that. I don't like to think about who I might be in that role with. So good point. What else do we have? Nobody sees anything else? The relationship with the client. All right, so I just call it sex with clients. So the sex with clients rule is often not understood by practicing lawyers because we all think, yeah, you can't have sex with clients. And then when you start talking about it, you find out, well, sometimes it's okay to have sex with clients. And then you think about, well, what happens if you're representing your spouse in some kind of a traffic ticket? You're having sex with them, let's say. They're a client. Does it violate? And there's whole jurisdictions that because of these, well, what about the times when it's okay to have sex with your client? They just don't even adopt the sex with client rule. They just refuse to put it into their code. Louisiana does, and then sometimes they say that, and then people poke fun at Louisiana. But I'll also tell you that Canada, the entire country, they've left it out because of those times when it's appropriate, and they figure that other rules will cover off when it's bad behavior. So the rule is that you can't have sex with a client unless you were having sex with the client before the representation started. Although I did have a student once say, all right, when you're volunteering for a nonprofit, the first thing is check out all the hot people, have sex with them all, and then just go off and represent them. And then I have to say, I'm not thinking that's what they meant when they put this rule together. So yes, the rule says it's okay if you had a prior relationship. Go ahead. Do you ever really know? Right. So I'll give you the straight up technical answer. The straight up technical answer is it depends on state law. So you have to look at what does the state law say when it comes to who is the client? You know, is it the board? And let's face it, sometimes you represent a board. Sometimes I've even represented the executive director and not the board. Sometimes you represent the organization, and it gets cloudy. And that's why I put it as a board member in instead of the executive director, so we can kind of go through that. So you got to be concerned about it. You need to know what the rule is. And again, this is not one of those things that is, I don't want to say prosecuted, but the people who are losing their law license or getting suspensions for sex with clients, if you read those cases, they're horrific. You know, this is not what we're talking about, but it's good to talk about it, because let's face it, when people are volunteering, let's say you would never think about having sex with a paid client, you know, somebody who's paying you. But out in the volunteer setting, I kind of see a different standard in my own observations out there. So I want you to have an eye on it that says, okay, you know, are they a client? Is this other person a client? And then, you know, I can't have sex with them. So you need to think about that. One last thing I'll just mention, then I'm gonna read the conclusion. When they're sitting around, and you'll run into this in your practice or your volunteer work, when people are sitting around talking about illegal things, you know, you can't participate in that. So I left her comment ambiguous. So I will tell you a best practice. When that comes up, just advise the group, you know, don't violate the law. And I think the best practice is you get up and leave, because you certainly don't want somebody to go out and do something illegal. And they said, yeah, well, our lawyer was sitting around when we planned it. And then you got to say, no, but I didn't say anything, or no, leave. If you're not there, you're not going to be in trouble. So blanket statement, don't break the law. Well, get up, walk away. And this isn't hypothetical. I've seen this more than once. All right, so the conclusion. So this is the fun conclusion. There was enough of a change in the political climate in town that a large portion of the county's lands were retired from grazing. Yay. The county even put up a viewing station for tourists to see the wild horses. The local bar association recognized Billy's contribution to the town by awarding Billy and Charlie the Outstanding Lawyer Advocate and Outstanding Dog Award for the year. Randy and Billy started a nonprofit to raise funds and awareness for all wild horses and burros. And in case you're wondering, Charlie continues to mount every tourist dog that visit Wild Horse. So with that, remember your lawyers, you got to follow these rules when you're volunteering. That's the main theme of tonight. So thank you for coming.